New developments on the murder of New York City college student as attorneys for the 13-year-old suspect in the stabbing death of Tessa Majors cast doubt on a police interview conducted at the time of his arrest. Now, both sides are agreeing to limit exposure of the taped confession, as it has been called. David Bruno is a criminal defense attorney to weigh in on this. David, thanks so much for giving your insight. It's a sad case here to talk about the holidays.
Yes, it is.
Kicking things off, the New York City Law Department and the legal aid lawyers have essentially come to this agreement. They want to limit the disclosure of who gets to see the statement that was made to the police. Why do you think they want to do this?
Yeah, a lot to unpack. About a week ago, there was a detention hearing where we did learn a lot about this statement. So I question why this is happening at this point, because this 13-year-old is detained. He's being held. And at first, they had to put forth evidence to probable cause, really. And we knew that he gave the statement. We know that he's not, the 13-year-old's not the stabber, the killer. And we knew that it was ultimately, it was a robbery gone bad. So now they're limiting exposure. Why? I personally believe there's the 14-year-old still out there that's not in custody yet. So if they limit it and they don't allow the 14-year-old some critical information, it could be used so that police can interrogate and try to get some specifics from the 14-year-old that's not in custody yet.
Right.
Also, it could be because it's a juvenile. They could have agreed that they want to limit the media exposure on this case because it's a juvenile, it's a 13-year-old, you know? And so there could be a couple of reasons.
So in this case and others, you know, you have one defendant in custody, one that's still out there, in theory, could be reading these articles. He's 14 years old, so someone could potentially be harboring him and helping him. So the idea would be you want to keep the statement away from those folks so they can't craft their own statement, or perhaps say really the exact same thing. No, the other kid was the one with the knife, that sort of thing.
Exactly, limiting that. And that 14-year-old reportedly was going to turn himself in yesterday and jumped out of a car, and police are looking for him there. So there are a lot of different issues going on. Also, we could talk about waiver. Who's going to be charged as an adult, and can they be charged as an adult? The answer is the
14-year-old may potentially have something to worry about.
The 13-year-old can't because of his age, but the line is 13, 14. The 14-year-old can. If he is the stabber, which we believe from the reports, then he's the one that actually killed her. That would be the most reasonable person to address as an adult, the 14-year-old.
Yeah, the Legal Aid Society's really raised a lot of concerns here, and they said in a statement, "We are absolutely troubled by the fact that our client," they're talking about the 13-year-old in custody, "was questioned and interrogated by police without an attorney present. We must ensure that our client's constitutional rights are not violated." Now, we see in a lot of cases the defense tries to get a statement thrown out. I mean, is that going to be the strategy here?
Yes, I'm sure. I mean, that's always the first thing that I look at in my cases, criminal defense cases, is that did the defendant give a statement? Because juries love to convict on the mouths of the defendant. And when people go in to be interrogated, they're advised of their Miranda rights. And when they waive, and if it's a good waiver, then the prosecutor could just press play. So certainly the defense attorney is going to be looking at that. But what I look at in that statement that you just read is they're saying that he should have had an attorney. But that's not the legal standard. You don't need an attorney unless someone invokes. For the 13-year-old, all the 13-year-old would have to have is a parent or guardian. And I'm also learning through reports that there was an uncle was present. So if the uncle and the juvenile both were present during the interview and the Miranda warnings were properly given and both waived and understood those rights, then it's going to be very difficult for a defense attorney to challenge the statement.
And meanwhile, still one 14-year-old at large. David Bruno, thank you so much for your insights.
Always a pleasure.
Happy
Merry Christmas.
holidays. Yeah.